call on Government Order of the Day number 4.
Exclusive Economic Zone and Continental Shelf Environmental Effects Transitional Provisions Amendment Bill, second reading.
The Honourable Dr Nick Smith.
Mr Speaker, I move that this Exclusive Economic Zone and Continental Shelf Environmental Effects Transitional Provisions Amendment Bill be now read a second time. Mr Speaker, this makes a technical amendment to the 2012 Act that ensures the 4 existing petroleum production operators in New Zealand's Exclusive Economic Zone have a smooth transition into the regulatory regime established by the Act. It's worthwhile to first give an overview of the legislative framework. Prior to National coming to government, there were no environmental laws within the Exclusive Economic Zone. It may seem to members opposite that that's not very significant. Well, actually, New Zealand has had an oil and gas and other activities operating in the Exclusive Economic Zone for over 40 years without any requirement for assessment of environmental effects, and I know members on this side of the House are proud of the fact that for that enormous area that's more than 25 times the land area of New Zealand now has an environmental assessments process. I'd further point out, Mr Speaker, that the view members on this side of the House take is that there are economic opportunities in that huge ocean area, but they should be taken in a way that's responsible, where there is proper environmental assessment, and this bill is about improving that regime. Mr Speaker, this bill was referred to the Local Government and Environment Select Committee on the 26th of February this year, and I want to acknowledge the work of the Chairman Scott Simpson and the other members of the committee for the work they have done on fine-tuning this bill. It received 5 submissions, and I think that in itself indicates that there's actually pretty broad support for this measure, and only 2 submitters sought to be heard in person. I do want to thank those submitters for their submissions and input. The transitional provisions in the Exclusive Economic Zone and Continental Shelf Act currently require that existing petroleum operators are able to undertake their marine consenting process before their pre-existing mining permits or privileges under the Crown Minerals regime expire. So, if a marine consent has not been granted by the Environmental Protection Authority that this government established before the expiry date, existing operations would have to cease. Now, that's not consistent with other transitional provisions in the law and inadvertently compromises the supply of New Zealand's oil and gas supply. Now, the Environmental Protection Authority is currently considering a marine consent application from Shod Tile Oil Services and their Maori operations. The Maori gas fields operates about 35 kilometres off the Taranaki coast. It's been in operation for 35 years. It currently produces about 20% of New Zealand's natural gas. I'm expecting the decision from the EPA in the next few days. Shell Tide Oil Services is the first of 4 existing operators to begin the full transition into this environmental protection regime and has been required to undergo a robust consent process. This is including submitting an impact assessment outlining the effects of the activities on the environment, the impacts on other interests, as well as identifying measures that it would undertake to avoid, to remedy or to mitigate any adverse environmental effect. The marine consent application was publicly notified, giving interested parties and the public an opportunity to provide input towards the Environmental Protection Authority's consideration of their application. This bill simply allows those activities in the Maui field to continue if for any unforeseen circumstance the EPA decision is delayed or in the event that it is appealed. It eliminates any possibility that New Zealand's energy supply could be put at risk from that Maui field. The implications for the Shell Todd Oil Services having to cease its Maui operations would be hugely significant to the New Zealand economy. This situation would have the impact on gas consumers as well as on the Crown's royalties and tax take. It is estimated that between 2008 and 2013, Mr. Speaker, the Crown received approximately $550 million in royalties, in resource levies and company tax from that Maui joint venture. Mr. Speaker, the government would have preferred that Shell Todd Oil Services had applied well in advance of the expiry date of its mineral privilege, so this bill would not have been needed. We want to ensure the situation is not repeated when the other three existing operators are required to apply for a marine consent transition to the new EEZ regime. For this reason, I am pleased with the refinements that have been made by the Select Committee and has been recommended in the bill. The committee has unanimously recommended amending the bill to specify that any of those existing operators must lodge their consent application complete with the Environmental Protection Authority at least 9 months before the expiry of that operation's mining permit or privilege. This requirement provides an incentive for operators to engage early with the Environmental Protection Authority well before the mining permit or privilege expires. This is because existing operators will have to ensure that their information and application is in full when it is lodged and able to be processed by the EPA. This requirement also addresses concern expressed by some committers at the committee that the bill as originally drafted gave petroleum mining operators an open-ended timeframe in which they could apply for a consent. The new 9-month timeframe in the bill encourages existing operators to submit their marine consent application early and providing for sufficient time for the Environmental Protection Authority to consider the application in line with those statutory timeframes. The marine consent process will be well established by the time the existing operators come up for the marine consent process, with the first not until 2025, so I do not expect that operators will have any difficulty in meeting the timeframes in the bill. As New Zealanders, we all value our marine environment and the resources that it provides. We need to ensure New Zealand's oceans are sustainably managed to support a strong economy, the natural environment, as well as our great Kiwi lifestyle. I remind the House that until this government passed that 2012 Act, there was no requirement for an environmental assessment. We have a regulatory regime, in my view, that is some of the most robust in the world in ensuring that we follow best international practice. This bill is going to ensure that there isn't any potential hiccup around the supply of that essential gas. It ensures that it is done in a safe and responsible manner, and it ensures that we respect the integrity of the process and the courts that may be subject to an appeal. It is now only a matter of providing the additional incentives for future operators as their consents come up for renewal. Mr. Speaker, I'm sure we're going to hear long howls of protests from members opposite that the bill was not necessarily perfect first time round. Let's just simply say we could have a blame game as to whether the fault is with Shell Todd Oil Services for not applying early enough, or whether we should have always provided for consents continuing in the event that there is an appeal. A common sense parliament would say, actually, having had more than 100 years without any environmental rules in this vast area of ocean is a huge step forward. This is a relatively minor, sensible amendment, and I'll be surprised if members of this House will not support it. I would finish with one closing point. Labor promised in 1999 that it would pass a law It did nothing in its 9 years in government. We've passed a bill and a law that is world's best practice, and I'm more than happy to be the minister that has to make a minor tweak such as this to ensure that it is a robust and fair regime, and I hope that the House will
member's
support the bill.
time has expired. The question is that the motion be agreed to. I call Dr Megan Woods.